It's a crucial day in the Supreme Court today. The top court is expected to seal the fate of free speech in its verdict on the validity of Section 66A of the IT Act. The controversial section empowers the police to arrest those who post objectionable content on internet and could be imprisoned for up to 3 years. A law student and several other petitioners challenged this section on the grounds that it interferes with free speech and appealed that it be quashed. The petitioners had argued that the definition of Section 66A is vague and it may lead to abuse of the provision. They also argued that even genuine comments criticizing a person are treated as an offence. The petition was filed in the aftermath of the arrest of 2 girls from Mumbai who had objected to a statewide strike following the death of Shiv Sena patriarch Bal Thackeray. Their arrest then fueled the free speech debate leading to the filing of this petition. It was also alleged that the police was misusing the section. Supreme Court in March 2013 came out with an advisory that a person accused of posting objectionable comments on the social networking sites cannot be arrested without police getting permission from senior officers like the IG or the DCP. Jugal Purohit now joins us live for more on this story. Jugal, what time is the verdict expected?
Court where Justice Kaneshwar and Justice R.F. Rohinton are deciding on this matter. But let's just tell for our viewers understanding, it's not just about 66A. It's about essentially how you and I deal with the internet. It's about 66A. It's about the advocacy. It's about blocking content. It's about cybercrime. The Supreme Court today is going to look at a bunch of petitions, not only about...
There seems to be some problem connecting with Jugal. Let's wait till the time Jugal actually fixes his audio. But it's a very, very crucial day, as Jugal was mentioning, because it's not just about 66A of the IT Act, but it's also about how you and I operate on the internet. It's about free speech, and it'll be interesting to see what really the verdict is going to be. We are expecting the verdict to be delivered anytime post 10:30 a.m. In just a short moment from now, we are expecting that the Supreme Court is going to pronounce its verdict on Section 66A of the IT Act. Senior lawyer Sanjay Hegde joins us in the studio at this moment. Morning, Sanjay. What do you actually make of this particular day? Is this going to be a very, very crucial day for people like you and me, for many youngsters who work or operate on the internet, who express their opinion on the internet? Because there is a fear. There's a genuine fear that internet and whatever is being spoken on the internet is being misused. The law is being misused to take action against such people.
See, there is a need for a law. Okay. Because sometimes there is hate speech. The internet, you also know, is used sometimes to incite trouble.
Yes.
But that law gets misused in a routine fashion. Routine criticism. Free speech in most circumstances is not dangerous. You need a law for danger, for actual clear and present danger. What was framed for that has been so widely interpreted that even if you criticize a union minister's son, for instance, you could have an FIR and things like that. So the Supreme Court has to rule A, on the constitutional validity of the law, B, to see whether that law can be if there are problems with it, whether it can be read down, whether directions can be given as to how that law can still be worked in a manner that is constitutional. The Supreme Court normally is hesitant to strike down legislature-made law as being totally unconstitutional. There may be circumstances when it does it. But the first endeavor of the court is to see whether it can be interpreted in a reasonable manner.
Sanjay, if you go into a brief timeline of this entire case, in March 2013, as we have also been reporting, the Supreme Court of various courts in the country have in fact said that suppose if you were to exercise, if the police were to exercise or charge someone under Section 66A, then prior permission has to be taken by a senior official.
Yes.
So that its misuse at the ground level is not possible, or at least can be checked.
Yes. That was an interim order. But despite that interim order, state governments have observed it in the breach. You will remember that recently there was an incident in UP. I am very doubtful whether there was permission from a senior officer which was taken. And maybe it is time to take away the power from a senior police officer to making it somebody very senior in the civil administration, like the Home Secretary himself. So we shall know shortly whether the court finds the section to be entirely unconstitutional, or whether it reads it down in a manner that it can be read constitutionally. These are two separate concepts. One would say the law is totally invalid. Then it leaves it open to the legislature to frame another law. The other is to say that the law is valid, but it will be valid only if these conditions are implied before the law is used.
Interesting, Sanjay, that you say that the need for a law does exist, because internet is misused as well.
Absolutely.
By the hate mongers, by people who should not be doing what they're doing. But should there be a strong law, and there being an obvious possibility of that law being misused, how should it be read? Because most of the petitioners in this case have said that certain provisions in the law are quite vague, and that is why some people who should not be punished have been punished.
Absolutely. You see, the essence of criminal law has to be clarity. You should know what is right and what is illegal, and what is criminal. If you do not know, if that is rendered subjective, what does grossly offensive mean in 66A? I might find something entirely tolerable. You might find it grossly offensive. Supposing I say what I think is entirely tolerable to you who think it's grossly offensive, has an offense been committed? So the other problem in India is often that registration of a criminal case is easy, and then arrests are a matter of routine. So by the time you disprove the case in trial, you have more than suffered a punishment. Therefore, it is very necessary that if at all that this law is sustained on the statute books, it has to be sustained only under very severe limitations.
Okay. Now, the one thing that I wanted to know from you, Sanjay, is the fact that this is not a problem which would be unique only to India. I'm sure there are other countries also where people would be, exercising free speech, would be saying things on the internet, criticizing on the internet. How is the law in, say, various other countries? Is there a precedent to something like this?
There are precedents. Each country treats it according to its perceived notions. You know that in Pakistan they've entirely blocked YouTube. But we are not
or
Pakistan.
In China, for that matter, where Google is not.
Yes, or in China. But equally, we are not that. On the other hand, free speech to the extent of even flag burning is protected free speech under the US Constitution. Where is it, and at what value as a society and as a constitution that you place free speech is what determines the perspective with which you approach the problem. That is the real interesting question for a constitutionalist.
So
like
it
me.
is, Sanjay, see, for a person, I'm breaking it down for a lay viewer right now. Suppose I am a Facebook user. Something has been written or posted in the US, which according to their law is not illegal. There is nothing wrong, right? Protected under the Constitution. I press like, or I press subscribe, or I share it with my friends. We have seen instances where in India, purely on the basis of liking or subscribing or posting or sharing, there has been, a criminal case built up against people.
That is because 66A has been so widely interpreted
Will
by
the Supreme Court then be looking into all these things in greater detail, or at least pronouncing its verdict on the basis of all
the
these
Supreme
things?
Court normally is concerned with the principle of the law,
Okay.
not with the actual application. Those actual applications will be largely illustrative. I was reviewing all the arguments made before the Supreme Court, and the case that you mentioned, that of Shaheen Dada in Bombay, that was also given as an illustration to the Supreme Court. I have no doubt that they will have all of that in the back of their mind while they sit down and interpret the law. A more recent example was this so-called ban on the Leslie Advin movie, India's Daughter. All that actually happened was that a policeman went and asked a magistrate for a ban on only one portion of the film. And 66A was invoked there also. And as a consequence, we think that there's a worldwide ban on the movie. I mean, that is not what the law is meant for. no matter how widely you interpret it, ultimately the courts will have to find a solution.
Absolutely. So that is why today is going to be a very, very crucial day as far as free speech on the internet is concerned. Sanjay Hegde, I would request that you stay on with us, because we are expecting that this verdict could in fact be read out any minute now. Post 10:30 is when we were expecting the Supreme Court to actually deliver a verdict in this particular case.